BP is appealing its oil spill settlement to the U.S. Supreme Court.
The reason? The company wants the High Court to keep blocking thousands of business claims payments. Eyewitness investigator David Hammer explains why this could present a conflict of interest for two Supreme Court justices.
Claims Administrator Patrick Juneau got word this week that he can start paying businesses' oil spill claims again for the first time since December.
This is a major step.
But don't expect more than 30,000 waiting businesses to collect quickly. While BP lost many big appeals in this case, it did win one that created a new policy on how losses are calculated. That new matching policy could save BP billions of dollars and should make Juneau's job far more time-consuming.
If their claim has to do with the matching issue, we got to run it through what's now been ordered is the protocol for the matching. We've got to run it through that process. It's a very complicated matter accounting-wise, and I'm not a CPA.
At the same time, BP wants the U.S. Supreme Court to block the claims again while it seeks one final appeal. One Supreme Court justice has the power to single-handedly stop those settlement payments. He is Antonin Scalia, and his son Eugene is a partner at Gibson Dunn, the law firm representing BP in this appeal.
Justice Scalia often finds himself in the middle of that debate for one reason or another, and here again he's in the middle of this one.
Another conservative Supreme Court Justice, Samuel Alito, also has a son, Phil, who's an associate at Gibson Dunn. Federal law requires judges and justices to recuse themselves from any case in which a relative, quote, within the third degree of relationship is an attorney on the case or has, quote, an interest that could be substantially affected by the outcome of the proceeding. Neither Scalia nor Alito step down when the High Court hears cases from Gibson Dunn. They cite a 1993 policy letter from 7 of the 9 justices at the time, including Scalia. The letter says they will recuse themselves if their relative is a partner and shares in the profits from the Supreme Court cases, unless the law firm sends a letter promising not to pay the relative his or her share of profits from all Supreme Court cases. And that's the arrangement Gibson Dunn has with Eugene Scalia, making it possible for his father to sit in judgment on dozens of cases involving his son's law firm.
There are different viewpoints on whether this is a reasonable approach to the problem. But at the end of the day, it doesn't make any difference. The U.S. Supreme Court sets its own recusal policy, and there is no appeal from it.
The issue is heightened in the BP case because of Scalia's power to block business claims payments on his own. He took a similar unilateral action to block a $270 million payment to Louisiana in the tobacco settlement back in 2010. That delayed the payment for 8 months, even though the Supreme Court never agreed to hear the case.
Justice Scalia may choose to refer this matter to the entire court or perhaps to another justice of the court, but historically Justice Scalia has bristled at accusations of partiality.
Gibson Dunn actually brags on its website about how often it gets its cases heard at the Supreme Court. The High Court accepts less than 1% of the appeals it receives overall, but Gibson Dunn claims it gets more than 30% of its cases heard. David Hammer, Eyewitness News.